Welcome to Engage in Trade. Today's topic is U.S. trade policy and the convergence of import and export compliance. I'm Susan Spitz, the Manager of International Business here at World Trade Center St. Louis. Thanks for joining us today for this very important topic, which is sponsored by our friends at the Missouri Department of Economic Development, the Office of International Trade and Investment. So global trade compliance experts at renowned law firm Thomson Coburn have been spreading the word about some important trends that they have noticed over the past few years. They've been seeing increasing regulation and reporting requirements across multiple federal agencies. And businesses, we find, are increasingly being asked to understand and attest that their supply chains avoid unfair labor practices, harmful environmental production activities, and the like. So these increasing regulations could actually apply to companies that are not even operating internationally yet, as well as to companies that are importing. Whereas up until now, most of these regulations pertain solely to exporting. So we're excited to help spread the word about these trends. Today's speaker will unpack some of the specific requirements and the agencies which are asking for this information, and then also discuss what businesses need to watch out for, whether or not your business operates internationally. So we are pleased to bring you this presentation. We are glad that you have joined us. Just a few housekeeping rules to let you know about. All participants will be muted for the duration of the presentation. However, if you wish to ask questions, please do so using the Q&A button at the bottom of your screen. We will do our best to get to those at the end of this discussion. There is going to be a lot to cover, but our speaker has promised that there'll be time for Q&A. So did want to let you know also that the slides and a recording of this presentation will be available about a week after the webinar is completed. So now it's my pleasure to introduce to you the Deputy Director of the World Trade Center, Ms. Stella Sheehan. Stella has been with the World Trade Center in St. Louis for over 18 years, and she leads the trade team consisting of myself and Annie Mbale, who is our webmaster today. She also heads up our Chancellor's Certificate in International Trade online export training. She oversees our 16 sister cities and is the executive producer of our signature event, Growing Global. Born and raised in Ireland, Stella has lived, worked, and studied extensively in international markets, including Belgium, France, Italy, and the UK. She holds a BA in French and Italian from the National University of Ireland at Galway, and an MA in Applied Languages for Business from the University of Ulster at Coleraine in Northern Ireland. She's also a graduate of Leadership St. Louis, and she was appointed to the Missouri District Export Council in January of last year. And as I always say, she's also the wind beneath the wings of our executive director, Tim Nowak, who's also on the webinar today. Stella, I know you're going to give a brief overview of World Trade Center St. Louis's work and introduce our speaker. So over to you, Stella.
Thank you so much, Susan, for that glowing introduction. And thank you all for joining us today for this most timely of topics in international trade at the moment, convergence. I, for one, am very excited to hear what our speaker has to say on this topic. As Susan mentioned, I lead the trade side of the house, and we like to say at the World Trade Center that we have three main pillars: people, trade, and investment, the three key equal ingredients which make up a global city. The people side consists, as Susan mentioned, of our 16 sister cities, and perhaps our most well-known initiative, our media darlings, as we refer to them internally, the Mosaic Project, the St. Louis Mosaic Project, headed up by my colleague, Betsy Cohen. And that is an initiative to attract foreign-born to the region and then assist them by way of programming and networking once they arrive. The trade side provides companies with the tools they need to trade internationally by way of counseling, referrals to our federal and state partners, and organizing educational events like the one you're attending today. Last but certainly not least, our foreign direct investment, or FDI pillar, is led by my colleague Sean Mullins, and that side of the house assists companies around the globe who may be interested in setting up their North American base in the region, or are already here and have chosen to expand and continue their investment here in the region. So without further ado, let's get to our speaker. Tyler Black is a partner at Thomson Coburn LLP. and an experienced international trade and regulatory attorney focused on the impact of federal law and regulations on both domestic and international business. He provides comprehensive trade compliance expertise on sanctions, import-export control, related laws that affect a variety of sectors, including insurance, financial services, manufacturing, telecommunications, aviation, and unmanned aircraft systems. In his work on international trade compliance issues, Tyler tracks business critical legal developments throughout the federal rulemaking and implementation process, conducts counterparty due diligence for a variety of manufacturing businesses and financial service providers, provides regulatory disclosures with the Department of Treasury, Department of Commerce, and Customs and Border Protection, and has weighed in on complex issues affecting both US and non-US persons and foreign subsidiaries, including emerging areas of the law, such as recent novel sanctions affecting Russia, Belarus, and Ukraine, and the impact of Section 301 tariffs and exclusions on product importations from China. Tyler previously worked at the Federal Aviation Administration, the Department of Transportation, and the White House, and is also a licensed private pilot and recreational drone enthusiast. So over to you, Tyler. Welcome.
Hey, everybody. Hope everyone can hear me.
Yes.
Excellent. Thank you, Susan, Stella, and Tim. Thank you for having me. Excited to be here today to talk about something that's been developing really over the last 5 years, but it's become more acute in the last year or so, and that's the convergence of two areas of international commerce that have previously relied upon somewhat different skill sets, and we'll get into some specifics. Let me start with the presentation here. Hopefully that's coming across.
Yep, I can see it.
Wonderful. All right, so we'll start out with kind of a 10,000-foot view of what's going on. This is our roadmap. The background really is kind of the way things maybe were before, not in a rigid sense, but generally speaking, import practitioners and export sanctions practitioners had different skill sets, lived in different ecosystems of government agencies, and went about their trade in kind of a different thought process. And increasingly, the global political and security landscape is driving these areas closer together. And the result of that is an interesting mix of tools from one of these areas or the other being used in a new way or in a new area that is somewhat novel. And there are some reasons for that that we'll get into, but that's really the topic, and the bottom line here for this topic is that if you're doing something in this space, this kind of overseas international transactions, whether it's import or export, you need to at least have a basic awareness of how both sides operate, because you might encounter some interesting and new ways that you're going to be regulated. So let's get into it. I kind of hinted at this, but new global challenges are creating different priorities for governments. And just taking the US as an example, it's encountering some new and increasing challenges from China. It's as a result of the war in Ukraine. It's confronted Russia and Belarus using some novel techniques, and its allies in the European Union and the UK are realigning their priorities, some of which are lining up with how the US wants to do things, and some of which is kind of its own, are aligning for their own purposes. So lastly, there's some increasing physical threats to international commerce, such as in the Red Sea, that are really of a bygone era that are now popping up again. And so supply chain integrity, sanctions, export controls are all now becoming, I'd say, front of mind for a lot of manufacturers and companies that maybe didn't have to worry so much about the details. This new era has been characterized as globalization 2.0, and the effect of that is that you can expect the government to use new and existing tools in new ways to confront these challenges. So the government is generally shifting from an efficiency priority to try to get as much trade and commerce accomplished as possible, to making something more, the supply chains more resilient and hardened against adversaries or peer competitors. And the result of that is not so much decoupling, but making sure that trading partners are more closely aligned with national priorities and policies. So it's going to become easier to trade with countries that are aligned and more difficult to trade with countries that are not. And we can see this, we can term this as kind of a whole of government approach to assessing the vulnerabilities and strengthening the national supply chains. So we see more and more a coordinated effort among Department of Treasury, Commerce, State Department, CBP to use the tools in its arsenals to coordinate an end effect, whereas maybe before Commerce would be interested in its silo of its portfolio of interests, and Treasury would have its priorities. And now we're seeing more and more something like a tri-seal alert about evasion of sanctions or export controls, or you'll see guidance that is published by multiple agencies that are trying to accomplish the same thing. So what that means is that often we'll see classic export control tools or skills that might be needed in an import setting. We'll see import knowledge that might be now needed in an export setting. And while we're early on in some of these developments, if we look to them now and try to understand them now, we won't be as surprised when they come into play in a more broad way or effect. So let's talk about these two different environments I've hinted at, and why are they different? Why would it matter that all of a sudden you're using an export control type regulatory structure in an import setting or vice versa? Well, it starts really with the foundation of where these two areas of the law came from. The import environment is largely a reasonable care or negligence environment. That's the legal standard that predominates. And because that's the legal standard, that also predominates decision-making in terms of how you approach a regulation or an interaction with one of these agencies. You have to be reasonable, you have to use well-documented procedures, you have to undergo training and auditing, but there is a certain amount of latitude if you have been reasonable but happen to be wrong. And so there are defined and predictable penalties in a way that maybe is not so clear on the export and sanctions side. And there are also some pretty explicitly defined disclosure benefits. You're dealing with a particular set of agencies on the import side that's different than the export agencies. And so they've developed their own culture and way of interacting with their stakeholders. HTS classification is a way of coding and understanding goods that are brought into the country. And while there are some applications of a harmonized product classification in the export arena, like Schedule B classifications that are similar. This is predominantly developed on the import side. So people who are trying to import items really have to understand these tariff codes so that they understand what duties apply, what programs, duty relief programs they can benefit from, and what additional tariffs may apply depending on temporary legislation. So diligence in this area is about knowing your supply chain, but classically, there hasn't been as much of a need to know that supply chain to the point of the genesis of the underlying material. Often it is, if I want to purchase a computer from a particular country, I want to know about who I'm purchasing it from, but I don't necessarily need to know who is producing each chip or how or where. Obviously, that's good information to know, but in the past, there was not as much of a consequence for not understanding that information. On the export side, we're dealing with a different legal standard that really colors a lot of the thought process and risk calculation. That's generally a strict liability standard. So if the bad thing goes to the bad country, you're on the hook, even if you didn't know that that was going to be the case, or if you reasonably believed that that wasn't going to be the case. So we're also dealing in a national security environment in a lot of respects, which means that there tends to be more judicial deference to these agencies, not all the time, but it is somewhat more difficult to challenge administrative decisions and penalties in this context, simply by the fact that we're in the national security space and the executive has an outsized role in that space. There are defined penalties, but there's quite a bit of wiggle room. And if you monitor the publications that describe violations and settlement agreements, you'll see quite the range of factors based on the facts and circumstance of each decision. So while you can understand the criteria for a violation, sometimes it's difficult to put a pin in the exact liability for a particular set of conduct. Similarly, disclosure has been afforded great weight to mitigating a penalty, but it's not necessarily as well defined as in the import context. Different set of agencies here, and there tends to be more of an extraterritorial reach to these rules and regulations on the export and sanctions side. So I like to think of the import, the sanctions laws as being more of an in personam type legal vehicle, where they are laws that apply to people and actions and conduct, and the export control laws as applying in rem to the property, and they follow the property wherever it goes around the world. And so that's somewhat different from the import context, where you're mostly dealing with what happens at the moment that you're trying to bring something into the country. So let's talk briefly about the framework in the import and the export space so we can understand better how they're crossing together. So we've mentioned that reasonable care is a negligence standard, but the rules are based on a coherent international set of rules that are harmonized to a certain level. This is called the harmonized system, and it provides a way for everyone to speak the same language up to a certain point about products that are crossing borders, and that's extremely useful. It's there are over 100 countries that use this system. It covers 98% of international trade, and the goal is to really have more of a uniformity, as much of a uniformity as possible in international customs regulations. There's a lot of interpretive guidance. Much of that is at the national level, but there are shared resources such as explanatory notes and other interpretations, international interpretations that provide as much cohesion as possible across different jurisdictions. So the way that a classification is made, I'm actually going to jump to the next slide. The goal is to, when you're classifying a product, is to find the correct tariff number. In the United States, it's a 10-digit tariff number, and it's harmonized. That means it's going to be the same pretty much no matter where you are to these first 6 digits. The chapters, headings, and subheadings to this level are shared. And then the remaining 4 digits here, the tariff stem and the classification number, those are set at the regional or national level, and that's where the actual rate of duty is assigned. And the way that you classify products is from the skill of interpreting and applying the general rules of interpretation, which apply across jurisdictions. And generally, it's to identify whether a product can fit into the terms and headings of any relative, and interpreting any relative section or chapter notes. It's to identify if you have an incomplete or disassembled product and handle it accordingly. And then in other cases, it's by determining whether or not a product has the essential character of one component versus another component. And the point of this is that there's a certain amount of interpretation that has to be done. And these interpretations have been adjudicated and opined by a series of agencies and organizations in the import context and not in the export context. And so I think what I'm kind of hinting at is that when you use a system that is designed for the import context now to target export controls, you might find that the agency that's administering those export controls is not as well versed in some of the detail and interpretation that has developed over the years on the import side. So the benefits of having this common system, again, are so that everyone can speak a common language regarding products. And I think that is why this is so enticing for export controls, because as we'll see here, export controls are a somewhat more complicated landscape. They're designed to, in the United States, they're designed to tackle both purely defense articles and dual use goods and technology, but they don't cover every single good in commerce. The harmonized system on the import side is really designed to be able to apply a numerical code to any potential article of commerce that's out there. That's not what the export controls have been designed to do. So when we'll get into this more in a minute, but you can see the attractiveness of a system that's designed to capture every single product that's out there when suddenly you're in an environment that you might want to be targeting commodities and non-defense related goods and technology for control, whereas you might not have a nomenclature in the existing dual-use export control regime. So let me back up just a minute. So in the United States, there are really kind of 3 pillars to the export control and sanctions area. There's the ITAR, International Traffic and Arms Regulations, administered by the Department of State, and that's for purely defense articles. There's the EAR, the Export Administration Regulations, administered by the Department of Commerce. Those are for dual-use goods, goods that may have a military purpose or use, or have been decontrolled, but also have a commercial use. And then kind of straddling both of these areas are the economic sanctions programs administered by the Department of Treasury. And as I mentioned earlier, these are programs that are primarily to regulate the conduct of U.S. persons, and in the case of secondary sanctions, non-U.S. persons, regarding what they can and can't do overseas, persons, countries, certain activities that they can and can't do. So these are each independent considerations. You might have a problem with economic sanctions, but not a problem with export controls, or vice versa. So they have to be independently evaluated for whether or not there's an issue. And we'll just talk mostly about the EAR here in the export control sense, but a lot of the similar considerations are in effect for the ITAR. So the EAR covers all items in the United States, all U.S. origin goods that are followed wherever they're located, foreign-produced goods with more than a de minimis amount of U.S. content, and in many cases, direct products of U.S. technology. The Commerce Control List is what actually sets out the dual-use items that are subject to specific controls. It's based on international agreements and arrangement, and there is some harmonization, but it is a U.S. list that is controlled based on U.S. National security priorities. It's controlled based on the destination and the and where the goods are headed or will pass through, but it's the Commerce Control List uses an alphanumeric numbering system to identify products, but it does not use a rule-based interpretive classification system like the import system. Classification rulings are private; they're not published, and there's a lot less guidance out there for classifying something on the Commerce Control List. Here's what an export control classification looks like. It's quite different from that slide that I popped up earlier with the fry basket. That's just the 10-digit number. It's based on the list categories, the product group, and then the control number in this order. And typically these controls list products with specific capabilities, not every single type of product that might have that description. So it wouldn't cover, for example, all frequency changers, but only frequency changers that are used in this particular way or have this capability. Here's what it actually looks like in the CCL. And so each description is up here. The countries to which the controls apply is in part 2, and then the capabilities are listed there in part 5. And so there's an interpretation that has to be done to see whether the product meets those capabilities, but oftentimes that is quite a different analysis than the analysis of the tariff numbers. Not every item has an ECCN, and that's an important jurisdiction. If something is not included in the Commerce Control List, it's termed EAR 99, and that's really most of the items up there. It's a basket category that includes most of the items in commerce. So the problem for some of these export agencies is that this doesn't allow them to control products that might be valuable from an economic sense, or might be valuable because they support an aspect of a regime that would be desirable if it discontinued. So there are some limitations to what the current export control, the Commerce Control List allows you to do. So the exporter responsibilities traditionally have been to know your product, know your customer, and know your destination. And this is more extensive than what the supply chain responsibilities have been for importers in terms of knowing where their upstream products come from. So in the export sense, there's a lot of work that has to be done to understand how the product is going to be used, where it's going to be used, when and by whom, and an ecosystem of contractual provisions and agreements and certifications has popped up to try to provide as much assurances as possible that a product is going to be used in a way that doesn't violate export controls. And that is something that will become more and more relevant now on the import side. So in terms of what sanctions programs have been over the years is as a tool to deter or penalize actors that are acting contrary to the national interests of the United States, to deny resources, or to provide an incentive or leverage to encourage actions that are in favor of the U.S. national interests. And so this didn't often have a lot of implication on the import side. A lot of these skills were kind of more important when selling abroad. That's not always the case, but I think a lot of these restrictions now are more relevant now that forced labor is becoming a consideration for importers. And we'll get to that in a minute. There are really three types of sanctions programs that are out there. There are comprehensive sanctions, and those are prohibitions on dealings with certain countries and governments. There are list-based sanctions that target particular designated entities and individuals. The SDN list being the most prominent, which is a blocking list that requires U.S. persons to block or freeze property they're in the possession of, and not deal in any services or goods or have any other dealings with such persons. And then there are sectoral or activity-based sanctions. Those have increased over the last few years, such that it's not necessarily enough to know that you're not in a comprehensively sanctioned country and you're not dealing with a person on the SDN list. You still have to understand if you're dealing in a sector or if you're providing a service or activity that is itself prohibited. So in the Russian sanctions program, for example, Russia is not comprehensively sanctioned, and you might find someone to do business with in Russia who is not on an SDN list, but you are still not permitted to provide certain services or engage in certain activities in Russia. And that is that's something that's been a tool that I'd say has really grown in popularity over the past few years. So how is everything coming together now that we've talked about what each of these different sectors has done in the past? Really, what is important here is that the skills in one legal environment are now becoming necessary in another. So tariff classification skills are now important in the export context. If you're trying to export anything to Russia or Belarus, for example, you need to have a good understanding of what the ordinary tariff classification of your item is. In the past, you would have understood it to be EAR 99, not export controlled to those countries, and you'd be able to conduct your transaction as long as you weren't dealing with a person who's blocked by the sanctions program. However, now there is a series under Part 746 of the EAR where you have tariff-based restrictions on EAR 99 items that control goods that are classified in a particular tariff subheading to Russia, solely based on that classification. So if you don't know that classification, if you can't make it yourself, you might not know whether or not you can legally do that transaction. Counterparty diligence. I mentioned a few times before that oftentimes the diligence of the party that you're doing business with overseas, if, for example, you're buying from a supplier in China, that diligence might have really ended once you understood what that entity, what that supplier was, what its ownership was, etc. Now you need to know where that product was made, with what components, what parts, what materials, and where those were made, and by whom, and when, and be able to document all that information. Because the United States has really been leading on blocking imports of products that were not only produced from forced labor directly, but also indirectly. And so supply chain knowledge is becoming essential for import compliance in a way that perhaps it was more important on the export side. So the reason that a lot of this is happening is that the government is seeking to coordinate its approach to various threats. So while it's kind of testing out these cross sector tools and seeing how they can be used to confront an adversary such as China, we're still in the initial phases of that. We don't see any tariff-based export restrictions on China right now. However, because it's such a surgical tool, and we've been testing it out in the Russia and Belarus context, there may come a time when knowing that information is important, because tariff-based export control goes into effect in some place like China. Now there maybe are not as many exports to China, but similarly, there could be activity or services-based restrictions related to China in a way that don't exist right now. And again, those are being tested out in other contexts like Russia. So I think one thing I want to pull out from this slide is that in certain areas, we've seen parallel adoption of these convergent regulatory regimes. So in the EU and the UK, they have implemented tariff-based export restrictions in a way that they did not have before. And to complicate matters further, these jurisdictions may not classify items the same, because remember, we're harmonized to 6 digits of our 10-digit code, but not the last 4. And so there may be differences in controls in those last 4 digits that have an effect where you can do a transaction from one of these jurisdictions, but not the other. And it might not be apparent because they both seem to be marching in the same direction. But if the rules are applied differently based on how the classification is made, then you might have a problem. Additionally, in the United States, these tariff-based export controls have been expanded over time to include components, parts, and accessories and attachments there too, even if they are under a different tariff classification that's potentially not export control. So you have to be able to understand what is considered a component, part, or accessory or attachment, based on how the law interprets those terms. So it kind of was getting to this, but this complicates an exporter's decision. And right now we're only in this environment in Belarus and Russia, but if this is a useful tool, if it's seen as being effective by the United States, it's going to be applied to different settings. And so if you're an exporter or you represent an exporter, understanding the implications of this import tool being applied in the export settings is very important. Reasonable minds can differ on some of these classifications. And when you're coming from a reasonable care, negligence standard environment where you have to make a reasonable and documented decision about what the classification is, but then you proceed, that's not the same environment as a strict liability export control setting where if your reasonable interpretation is not the same interpretation as the government's, then you will be deemed to have broken the law. And so we're kind of we're misaligned here in terms of what the law was developed to do and what it's being asked to do. And it will be interesting to see how the export agencies coordinate with the agencies that have been a part of developing this body of law on the import side to see how they interact to resolve some of these incongruencies. So I'll give you an example based on that fry basket product that we classified. So say we have a US exporter that's exporting via an EU distributor to a private entity in Russia. It's selling a fry basket typically used with a deep fryer machine, but it's not selling the machine itself. It wants to know, can the transaction proceed? But before 2022, this would have been a very straightforward exercise. You screen the parties for sanctions and export control concerns. You use the appropriate contractual protections. But after this convergence, the considerations really multiply. So you have to really understand, not only is this an EAR 99 product, which it is, but what is the HS classification for this product? Is it controlled for export under EU law? What about under US law? Are the recipients subject to blocking sanctions and EU asset freeze targets? That was the case beforehand, but now there are a lot more of them. And they are ownership based in the United States and ownership and control based in the EU. They're not necessarily always explicitly listed by those jurisdictions. And are there any debt or financial or sectoral sanctions that might apply? Is there an EU analog for those types of sectoral or activity sanctions? So there's a lot to think about for a very simple transaction. And if you look at some potential room for differences, one body or jurisdiction might consider this a part of that machine, and another might consider it to be its own stainless steel apparatus. And so you can make an argument based on precedent and guidance and what the tariff says, and there might be some reasonable room for differences. But it matters all of a sudden when one of those reasonable classifications is controlled for export and one does not. How would you consider the risk there? What is the safer classification from an export perspective? A lot of these are kind of novel considerations when we were previously dealing with maybe an EAR 99 environment where you put it in that basket pretty comfortably and you don't have to think twice about it. So I got hinted at this a little bit earlier, but how would the Department of Commerce, for example, an export authority, evaluate an import classification? And they've hinted in some guidance recently that they acknowledge they are not able to classify goods by HS code, and they may rely on a formal determination of an item by the import authority, CBP. But this is a process that can take a little bit of time. And so you might not be able to be as nimble as you were before if the Department of Commerce thinks that there's a genuine issue here in terms of whether or not an export control applies, and has to rely on another agency to actually render that judgment. Another example here is the way that you can modify a product and change the classification accordingly based on those modifications. That's sometimes referred to as tariff engineering. But in the export control space, there's a concept called circumvention and evasion, and it's really unclear how an export authority might consider you adding one aspect or another to a product that would change its tariff classification. It's unclear whether or not it would consider that to be circumvention in any case. That's something that we're going to have to see play out, and maybe we could get some more guidance on that. That would be great. But for right now, that's kind of a gray area. On the import side, we have more concerns about regional imports from regionally restricted areas, such as the Xinjiang Autonomous Region of China, and somewhat relatedly, forced labor-related inputs to supply chains. So understanding where products come from, how they are made, in a way that goes to the genesis of that product is increasingly important. So you have to ask yourself as an importer now, how much diligence have I really done on my upstream suppliers? Do I have every single one well documented? And is that document going to hold up under scrutiny? Goods can be blocked from entering the country if they're Xinjiang origin, if they are from a company, an entity that is blocked on a forced labor list. And so you really have to know and trace your supply chain in a way that can verify not only the origin, but also can exclude forced labor from that supply chain. And so I see I'm running a little bit low on time, so I'm just going to skip ahead to kind of the takeaways for how you can use skills in both of these areas to your benefit. You can always develop better know your customer or supplier due diligence policies, screening skills. Do that for imports as well as exports. You can try to understand and read the guidance that is coming out of this kind of new area from these different agencies that are telling us how they're going to regulate. You can understand the HTS system if you're an exporter, but you haven't had to do that before. You can communicate these types of restrictions to clients, customers, et cetera, the types of demands that are being asked of you, and get the information in advance as opposed to waiting until you're audited. And you can evaluate import decisions using an export lens, a strict liability lens that maybe you didn't have to do before. And all of these things will hopefully make transactions more bulletproof, but they are more resource intensive. So the challenges are there, and we will all have to see how they continue to play out.
Wow. Okay. Thank you, Tyler. That's
That was a lot.
a lot of detail, little bit scary or whatever. It's a lot to think about. So I would encourage participants, sorry that you aren't going to be able to verbally ask a question, because it might take a little typing to put your questions in the Q&A, but if you would do that, and I've got a question or two while we wait for that. But I guess just the big one that comes to mind for me is like, what's the best way to sort of stay on top of this as these things continue to change? I don't know if you guys have an e-newsletter that goes out, or is there some general place that you would suggest people to go to make sure they're
Well, most of these agencies have publications that they do regularly, identifying changes in how they're going to approach something, new regulations, rules. I think in terms of monitoring updates, if you really want to know what the law is, you got to monitor the Federal Register and what the different agencies are publishing, and that's a lot of information. And so we publish articles and client alerts and things of that nature, but it's not really a substitute. That's kind of that's a broad that has a broad audience, and you are your own company or entity that really has to know what you're most concerned with. So going to the well yourself is usually the better way to go, and they usually have some subscription method for that. But in terms of what people and companies can do now, it's really really get into knowing yourself and your products and where you do business, and then from there you can understand what restrictions or extra duties or vulnerabilities attached to those products or those countries. And just starting to develop a web of those kind of risks is the best way to then decide what you do about them, what you need, how to address those problems.
And of course, if they have retained a firm like yourselves, and that would be a good way to keep up with it as well.
Sure.
And then, of course, we've also got World Trade Center and our partners like the U.S. Commercial Service, and the state of Missouri can help with some of that as well. I know that there's been emphasis on this, the Xinjiang area for forced labor. Can you give an example of what would be reasonable care for that?
Sure, yes. CBP has actually published a list of what constitutes reasonable care in the forced labor context. And it's 9 or 10 points, but really it comes down to establishing reasonable procedures and then following through on those procedures. So those procedures are going to cover things like knowing your supplier, knowing your supplier's supplier, understanding where the goods were produced and being able to prove that, and being able to show that you've educated your personnel, that they understand the resources that are available to them that are published by the government on identifying red flags in this area. And then that when you encounter problems or red flags, you're able to escalate and resolve them. So being able to show that you have a way of preventing problems from happening and dealing with problems that do arise is your best way to demonstrating that you're behaving reasonably.
Okay. So I know that I've heard from your colleague, Robert Shapiro, that a lot of times it's hard to get that information, right? The supplier's supplier and things like that. So it's good that there's some, written instructions on what's reasonable and how you can, sort of.
Yes, but Robert's right. That doesn't mean that it's easy. And at a certain point, this is the same thing in the export or sanctions area with respect to Russia. at a certain point, when there are so many of these different myriad restrictions that are hard to comply with or understand or document, your takeaway has to be that the government doesn't really want you to do this kind of business, even if there maybe are ways to document your way through something. So there's always the option of moving the supply chain or shifting it. It's not always easy. It's not always quick. It's not always even feasible. But the government kind of wants you to do that at this point if you can't prove it out. If you're not able to get that kind of documentation, the conclusion might be, well, you shouldn't do that business then.
Yep. As you say, that's what they're trying to do, right? So, okay, well, we really don't have any time for more questions, but I want to, maybe you can just briefly answer this one question of what are the implications regarding the upcoming US elections? Like, how would that affect some of these convergent concepts?
I actually think that that's an area where there's not going to be too much effect. You might have different degrees of tariffs in one administration versus another, but this is an area of bipartisanship in terms of confronting adversaries such as China. And the tools that are being developed now are going to be useful no matter who is in the White House next year. And so you're really seeing, I think you're seeing things that are not going to go away. It's just maybe a question of who and how they're going to be used.
Okay, great. Thank you very much. If you wouldn't mind stopping the screen share, we'll put up a couple of closing slides, and just wanted to remind people that this presentation is being recorded and will be sent out. Very, very timely, very important information. We do have some upcoming events, and we would also love your feedback. So I'm trying to get my notes up here. Just there's a QR code on the slides. I don't know if Andy's going to be able to get those up there, but let me just tell you about the upcoming events we have on May 30th. We've got a networking reception and the celebration of 30 years of the sister city relationships between St. Louis, Missouri and St. Louis, Senegal. And then also our next in the series of Engage in Trade is going to be Wednesday, June 26th in the morning, in person at our offices, and it's going to be covering mastering global shipping and logistics. I think it'll be a really great topic with some insider tips and a great overview. And so those are the two events that are coming up. You can find them on our website as well. And we would really appreciate you giving us your feedback on how this presentation went and any other topics that you would like to see us cover. And thank you again to our sponsor, the Missouri Office of International Trade and Investment. And with that, we will end the webinar. So thank you very much.